The interim interdict is sought to suspend any further steps being taken to continue with the private prosecution, including the requirement that the applicant is compelled to appear before a criminal court on the 19th of January. The charge against the applicant is that he is either guilty as an accessory after the fact to a crime committed by Advocate Downer SC and a journalist, Ms. Maughan, or of obstructing the course of justice by facilitating them evading justice. Advocate Downer and Ms. Maughan are alleged to have contravened Section 41(6) of the National Prosecuting Authority by publishing confidential information about the respondent's medical history. But that trial has not yet begun. Pertinent issues are, straightforwardly, whether a case is made out to interdict the further proceedings in the envisaged private prosecution. The very appearance of the applicant before the criminal court is what is sought to be prevented by the relief sought in this urgent application, which is premised on the contention that to appear in a criminal court would be to submit to an unlawful intrusion on the rights to freedom of the applicant, if the private prosecution is unlawful for want of proper authority. Herein lies also the key factor that demonstrates the urgency relied upon in this matter. The trial date is 19 January 2023, less than a week away. If the aim is to avoid having to appear, the matter before this court is urgent. In our legal system, the only agent that can lawfully bring a criminal prosecution is the state. There is an exception to that exclusivity where the state declines to prosecute a party. A certificate may be obtained from the National Prosecuting Authority to open the door to a private prosecution. That certificate is usually known by its Latin name, a noli prosecui. It is contended that a noli prosecui should name the persons who the National Prosecuting Authority decided not to prosecute in order to be valid. On these papers, 2 noli prosecui were issued. The first named Advocate Downer, upon demand to the National Prosecuting Authority by the respondent, who wished to also charge Ms. Maughan. A revised document was issued omitting his name and stating any person. It is claimed that because the charge levelled as an accessory after the fact or of obstructing the course of justice is a crime that could be committed only after the principal crime had occurred, and the noli prosecui refers only to the date of the principal crime, the noli prosecui could not have contemplated a crime by the applicant. In our view, a prima facie case of a right to personal freedom being violated has been shown. It was argued that the harm of appearing in a criminal court on the 19th of January was not material. This contention misses the point. The harm lies not in the temporary inconvenience of physically attending a hearing. The critical harm concerns a fundamentally, constitutionally guaranteed right to personal freedom. That value may never be treated lightly. Among the contentions advanced why the threshold for an interdict has not been cleared was that of the decision in the outer case. It was said that this case applied to a decision taken by a private prosecutor. Outer case had held that where it is sought to interdict a statutory authority from performing a function within its remit, a higher threshold existed than when seeking such relief against a private litigant. The contention advanced to us was that a private prosecutor exercises statutory authority and must be treated alike. This is not correct. The outer case cannot be applicable. Is there a viable alternative to relief in the form of an interim interdict? In our view, plainly, there is not, as it would require the applicant to appear before a criminal court and by so doing implicitly submit to a process which he claims is unlawful. Were the applicant to succeed later to have the private prosecution declared invalid, the harm of the submission to unlawful action cannot be undone. The respondent suffers no harm if there is a delay. The trial of the alleged principal offenders has yet to begin. Their conviction is a necessary condition for criminal liability. It is for these reasons that an order will issue in the following terms. The application is urgent, pending the final determination of Part B. The first respondent is interdicted from taking any further step against the applicant in any way.